Hi, my name is Isha, and welcome to Law and Looks, where I smoosh together law and makeup to talk about some of the more fun and interesting cases that I learned about in law school while doing my makeup. Quick disclaimer, nothing I say is legal advice. I cannot give you legal advice. Everything is purely for informational and fun purposes. If you do need advice on a particular matter, please seek out your own attorney and obtain advice from them. Okay, I think we're ready to get started. Put my hair up, check my nails. Okay. What do we got? What do we got? What do we got? So today I want to talk about a classic case that every single law student and lawyer in the United States knows about, and they will all collectively groan when I say Palsgraf versus the Long Island Railroad, or LIRR. Why will they collectively groan? Well, this is a legally significant case that deals with the causation element in a negligence action in torts. Specifically, it deals with proximate cause. My skin is not doing so well today. It's very humid outside, and I think my skin doesn't like that. But I don't want to get too in the weeds of negligence actions and proximate cause. No thank you. Instead, I want to talk about our plaintiff, Mrs. Palsgraf, who she was, where she came from, at least whatever details are out there. I want to talk about what is going on? Okay, there was like a weird thing happening with the door. Where even was I? I want to talk about who Miss Palsgraf was. I want to talk about the events that led to the case, what exactly happened on that fateful day. I want to talk about why I think Miss Palsgraf was denied justice in this case, and the aftermath of Miss Palsgraf and her family, and basically what followed for all of the parties involved. So, let's set the scene. We are in the summer of 1924 in New York City, specifically in August 1924. So it's hot, probably smells like garbage, and all of the rats probably running around. Miss Palsgraf hails from Ridgewood, Queens, which sits on the border of Queens and Brooklyn. It's unclear what her socioeconomic status and marital status is at this time. Lots of historians report that she's penniless, but she was married at one time to a very well-off tinsmith named Michael. However, they were divorced by 1927. So whether they were divorced by 1924, I don't know. Whether she had money in 1924, also don't know. She has 3 children, William, Elizabeth, and Lillian. And on August 24th of 1924, Miss Palsgraf and her 2 daughters, Elizabeth and Lillian, decide to take an excursion to Rockaway Beach. I lived in the city for 3 years and I never went to Rockaway Beach. But Miss Palsgraf and her daughters were off on a girls' day to the beach. So they arrive on the LIRR platform, purchase their tickets, and go to wait for their train. Lillian kind of wanders off and goes down the platform to see what's up at the newspaper stand. As they're waiting, a train pulls in. This is the wrong train. The train that pulls in is going to Jamaica, Queens, and from there will go to further points north. So they don't want this train. So the Palsgrafs don't get on. But as the train starts pulling away, 2 or 3 men run after the train to try and get on. The first man makes it on. He jumps on, makes it on with no issues. The second man attempts to jump on and has a harder time because he's simultaneously pushed by a platform guard and pulled up by a train employee. All 3 men were carrying large packages, and in doing so, the package that he was holding falls in between the moving train and the wall where, you know, where train tracks are laid, like it's kind of like a pit where the tracks are and there's like that wall. So in between the moving train and the wall, the package falls. When the package falls, it creates a huge explosion. Why was there a huge explosion? Because the package had a bunch of fireworks in it. So panic ensues from the explosion. There's people running like away from it, either due to the explosion or because of the pandemonium that ensued from it. There's a penny scale that topples on to Miss Palsgraf. A penny scale is essentially a luggage scale, a coin-operated luggage scale. It's like kind of like big and metal, and it falls on top of her. Because of that, Miss Palsgraf is injured. She suffers some bruising and contusions, and then subsequently suffers what we would call today PTSD in the form of stuttering and nervous fits. The third guy never made it onto the train. He just kind of like disappeared. But miraculously or something, the package that he was holding was left completely untouched, in pristine condition, on the platform. A few years earlier, there had been a bombing on the corner of Wall and Broad Streets that had left about 300 people injured. So New Yorkers were very on edge from these like anarchist bombings. So the bomb squad was called in, they inspected the package, and they found that it contained 6 fireworks. Now, these 3 men completely disappeared, nowhere to be found. Witnesses mainly described them as Italian men, and the fireworks that were found were said to be Italian-style fireworks that were made so that when they went off, they would produce red, white, and green colors to represent the Italian flag. The media, in order to calm the public's nerves, attributed this explosion to those crazy firework-loving Italians and said that the men were likely going to a Italian celebration of some sort. So the 3 men have completely disappeared, and Miss Palsgraf wants justice. Rightly so. So she sues the LIRR for negligence. It's probably better to sue the LIRR for negligence anyway. They have deeper pockets, and Miss Palsgraf won't have to like run around trying to find these men. And also, as a common carrier, the LIRR owes Mrs. Palsgraf a heightened duty of reasonable care, as she is a passenger. So she goes ahead with her suit. Now, initially at trial, Miss Palsgraf wins, and she gets a jury verdict for $6,000. But the LIRR appeals all the way up to the highest court in New York, the New York Court of Appeals, which is oddly named. In most states, it's the Supreme Court of that state, but in New York, it's the Court of Appeals, whatever. Just let New York be weird. Anyway, so at the Court of Appeals, the LIRR argues that there is no causation as a matter of law, and they focus their entire appellate brief essentially on proximate cause. I don't want to get too into the weeds of torts in a negligence action because, let's be honest, that would be incredibly boring, but let me just do a quick primer. Just briefly, a negligence action requires 4 elements. You need to show a duty, that the defendant owed you a duty, a breach of that duty, that the defendant failed to live up to the duty that she owed you, causation, both actual and proximate, this is the element that we're going to focus on, and damages. You got to show that you were injured, show that you were harmed in some way. So for the causation element, there are 2 prongs. There's actual causation and proximate causation. Actual causation is factual causation. We use the but-for test. But for this happening, the injury would not have occurred. For example, but for the defendant running the red light, the collision would not have happened. Defendant's counterargument to that would be, even if I was careful, the injury would have happened anyway. Now, if you think about it, whenever an injury happens, there can be a lot of actual factual causations, right? You can like pull a lot of, but for this happening, the injury wouldn't have happened, but for this, but for this. So proximate cause exists to limit the liability. And it's a confusing concept. I didn't fully understand it when I was in torts. I kind of get it a little bit better now. Ultimately, proximate cause is rooted in the concept of fairness. Would it be fair to hold the defendant liable for the plaintiff's injuries? That's the ultimate question that we're asking. It's kind of a public policy issue. The most common test for proximate cause in the US is foreseeability, which brings us back to our case. Writing for the majority opinion is Judge Cardozo, and he says that Miss Palsgraf is not a foreseeable plaintiff and that the LIRR was not negligent towards her. He writes that the plaintiff must show that some wrong was done to her. Violation of her rights occurred, not someone else's. Basically, according to Cardozo, the guards who were helping the second man get onto the train were negligent in doing so towards that second man and caused the package to be dislodged and the explosion to occur. But there was nothing to indicate that the package contained fireworks and, if dropped, would cause an explosion. The explosion, Judge Cardozo writes, caused scales at the other end of the platform to fall, striking the plaintiff. The guards, Cardozo argues, were not negligent towards Miss Palsgraf, who was standing far away when the package was dropped. So, in the end, Miss Palsgraf loses. Here's the thing, though. Here's my gripe. Judge Cardozo is wrong. A dissent was written by Judge Andrews that honestly makes a lot more sense. Andrews stated that proximate cause is, and I quote, "a matter of convenience, of public policy, of a rough sense of justice, in which the law arbitrarily declines to trace a series of events beyond a certain point. This is not logic, it's practical politics." Because in the end, the law also has to be practical. You can't just aspire to be some lofty abstract thing. It's gotta work within real world facts, even if they're bizarre. Cardozo also mentions that negligence doesn't exist in an abstract world. It's gotta be rooted in real human-to-human interaction. But the rule that he comes up with fails pragmatically. Additionally, Cardozo does a further injustice to Miss Palsgraf in the recitation of the facts. He basically omits anything about Miss Palsgraf. He doesn't even call her by her name. He just refers to her as the plaintiff, which is, yeah, it's standard sometimes in these cases, but it goes further than that. The facts are just reduced to a bare minimum. Judge Posner, who has written a book about Cardozo, which I'll link to below, called the recitation of the facts as elliptical and slanted. For reference, Judge Posner is an extremely influential legal scholar, and he was a judge on the Court of Appeals for the 7th Circuit, and Judge Cardozo is also an extremely well-respected judge. He was also a Supreme Court justice. But anyway, going back to Cardozo's recitation of the facts, he doesn't talk about Mrs. Palsgraf or her background. He doesn't talk about the original trial, the jury verdict, what her damages are, what she's seeking. He also describes her as simply standing on the platform, not as a customer. He downplays her role as a paying passenger of the LIRR. The explosive package is also described as small, even though witnesses all say that it was pretty large. And he also describes the penny scales and Miss Palsgraf as being extremely far away, like 30 to 40 feet away on the other end of the platform, whereas the record does not support this. The record indicates that Miss Palsgraf and the penny scale were more likely like 10 or so feet away. It's thought that Cardozo may have confused Mrs. Palsgraf with her daughter Lillian, who, if you remember, went down to the newsstand. Miss Palsgraf actually challenged that part of the opinion in a petition for a rehearing, but was denied, presumably by Cardozo, in one sentence that said her being closer still wouldn't have had her come into the zone of foreseeability. All in all, to me, Cardozo Cardozo failing to describe Miss Palsgraf as a paying customer of the LIRR and making her a foreseeable plaintiff completely denies Miss Palsgraf justice. What do y'all think? Do you think Cardozo was right? Was his analysis correct? Do you guys think Andrews's analysis was better? Or neither? Or none of this makes any sense at all? Because that was me when I first learned about proximate cause. There is like a ton of literature out there. People have analyzed Palsgraf over and over and over again. The rule outlined in this case by Cardozo isn't really followed by a lot of other states other than New York. Let New York be its weird little self. There's also this theory that Cardozo attended a conference on torts a few days before he was tasked to write the majority opinion in this case. That influenced his writing and his arguments. There's another theory out there that says that Cardozo and Andrews pre-planned to have this debate via this case through both of their opinions. Some people also argue that Cardozo wrote this opinion specifically the way that he did with the bare minimum facts so that it would go down in history and become a legally significant opinion and that it would be taught in law schools all over the country. I don't know, maybe he did that. What I do know is that there is a lot to unpack in this opinion and you can go down your own little rabbit hole. This could seriously be like an hour-long video. I don't want to do that, so it's not. So what happened after? Well, Miss Palsgraf was pretty mad with how the case ultimately turned out, and she remained bitter and mad, understandably, until she died in 1945 at the age of 61. By then, she had become mute, presumably from the stuttering that had resulted from her injuries and unresolved trauma. Judge Cardozo was appointed to the Supreme Court by President Hoover in 1932, where he served until his death in 1938, so not a very long stint, but he was there and he made an impression. Judge Andrews retired in 1928 and he passed away in 1936. So as the case gained notoriety in law schools and among lawyers, members of the Palsgraf family encountered some shocked or stunned reactions from members of the legal community. Wikipedia has a story from Miss Palsgraf's grandson, Frank Palsgraf. Yes, I do some of my research on Wikipedia, don't hate. But in 1978, Frank Palsgraf was treated like a celebrity when he was called to jury duty by a prosecutor, and the judge reminisced about his law school days and learning about Palsgraf, and the prosecutor ultimately struck Frank Palsgraf from the jury. So maybe the Palsgraf family never had to do jury duty because of this. And in 1991, this is also from Wikipedia, Lisa Newell, the first cousin 4 times removed of Judge Cardozo, married Miss Palsgraf's great-grandson, J. Scott Garvey. So the connection between Judge Cardozo and Miss Palsgraf just became closer. Hair down. Bum, 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 bum. And that, my friends, is Palsgraf versus the Long Island Railroad. Thank you so very much for watching. I hope you all have a fantastic day, and I will see you all next time. Bye!